Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Here, all persons having business with the appellate, please draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time you need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. More than 5.5 hours of argument time has been requested, so please listen to my admonition. We've read your papers. We're familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you have asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you're requesting. People versus Ortiz. 4 and 1 and 4. Hernandez versus 207 East 14th. Submitted. Maurice versus Michelle. 5 and 2 and 5. Lin versus Sewell. 5 and 1 and 5. Esterson versus Spring.
Respondent requests 8 minutes and 4 minutes for rebuttal.
Anybody else here? Seems like you have no opponent, counsel. Would you like to address us for a couple of minutes, or do you want to submit?
I would like to address the court.
I'll give you 2 minutes. Okay. People versus Petrie. Submitted. Dar versus Saj Transportation.
Good afternoon, Your Honor. Appellant's request 5 and 1, please. Respondent request 5.
5 and 1 and 5. American Bridge versus Contract Dispute Resolution Board. 5 and 1 and 5. Council of City of New York versus Mayor Eric Adams. We're going to take that case up first, so that'll be the first case argued today. Let me hear what you want for time. I was wondering about that. Did you allocate time between yourselves, or you want? Okay, thank you. And I will give you 5 and 2 and 5 and 2 and 9. Silverstein versus CoolSculpting. Okay. I'll give you 5 and 2 and 5. People versus Andre Barrios. Submitted. Rudkosi versus NYU. 5 and 1 and 5. Samsung Electronics versus MPEG LA.
Good afternoon, Your Honor. For appellant would request 10 and 3, please.
Respondent request 10, Your Honor.
Give you 6 and 2 and 6. New York Park versus ADBH is submitted. Okay, the first case we'll call is Council of the City of New York versus Mayor Adams.
Step up.
Please.
Good afternoon, Your Honors. My name is Wamika Ajibi. I represent New York City Council. I'm the Deputy General Counsel. The mayor's case lives or dies based on the definition of social services district. All three of the mayor's preemption theories require this court to adopt a definition of the term that violates basic rules of statutory.
If we think it's field preemption, or if we think that that's the best argument, what field are we talking about?
Your Honor, the field is residential assistance. So the question of whether a local legislative body like New York City Council can pass local laws as it relates to supplementing the state's vision for rental assistance and vouchers. The courts on these issues have always looked at the question of the specific field of social services law. The social services law is a vast codified instrument, and so there's lots of different provisions. Some have a skeletal body that the city can supplement.
Supreme Court defined the field as social services. Why was that incorrect?
As social services, because it was too broad. The court didn't look actually at the previous cases, and it also didn't look at what the state Attorney General did itself in Clarkston. The question of field preemption is really one about analyzing what the particular state did and how it intended to operate in the field. Here we say that the state has been clear about its desire to work with city DSS as an administrative body, but it hasn't foreclosed the city from engaging in policymaking. There's an important distinction between the task of administering thousands of millions of state and federal funds.
Well, city DSS can also make policy, right? I mean, they can propose policies. They did. The original FEPS program was proposed by them.
Yes, Your Honor. Our argument is that the state law is explicit about it being the city, and there's different components of the city. So city DSS can engage in a new idea as long as it's consistent with its mission, and the council can also participate in the process.
Well, I'm sorry, what defines their mission?
The charter. So section 603 of the charter talks about what city DSS does. And it's actually really interesting because it mentions both the authority under the state social services law as well as its the authority cabined by local law. Like a lot of city administrative agencies, city DSS can both respond to the state and to the council. And the definition that the mayor provides here is not at all based in a proper reading. At least 9 different provisions of the social services law would be rendered nonsensical. The clearest example is section 91, which refers to the legislative body of a social services district. City DSS doesn't have a legislative body, but the city of New York does. The council's position is that the state intended what it wrote when it defined social services district as the city of New York, and the state intended what it wrote in section 56 when it said that the city could engage in local lawmaking in the area of social services.
So I have a question related to remedy. If we were to agree with you, as I understand it, what you're asking for is that the mayor or city DSS would make application to state DSS for approval of the plan incorporated in the reform laws adopted by the City Council. Is that correct?
Yes, that's correct, Your Honor.
Okay, and are you asking for any remedy other than that?
No, no.
Okay.
We acknowledge that the state
And are
has
you asking for it as a mandamus or a declaratory judgment, or is
a writ of mandamus ordering the administration to start implementing. And that first step in implementation may be to go to, would be to go to OTDA.
You're not asking that it take effect the next day?
No, not at all, Your Honor. The
And a
council
specific
recognizes-
mandamus to go to ODTA, which is an acronym that's very hard to pronounce. ODTA.
Yes, that's correct, Your Honor. The council acknowledges that the state plays a role ultimately in approving any policy that anyone in the social services district creates, whether it be city DSS or the city council.
What about the mayor's argument that it's an iterative process usually when city DSS goes to state DSS, but here you have legislation which is specific and is not subject to, that has no wiggle room in it, so that that implies that in fact the legislature, the city council, cannot propose legislation because there's no ability to have a back and forth with state DSS.
That's just not a recognition of actually how city government works generally. There is a number of instances where we pass local law that can't be fully implemented until the state also takes an action. Example is Local Law 26 of 2024. Another is Local Law 118 of 2023. As the city is not
Please continue.
the city is not a sovereign. Every action that the city council does is always subject in some way to the state overriding its action. And we think that this is really not different from most of what the council does.
Has the state weighed in at all?
Your Honor, yes, it has weighed in indirectly in 1990. It explicitly embraced a local law that the city council passed that directed city DSS to create a housing plan, and that local law was amended to do substantive obligations for city DSS. They were required to no longer use welfare houses for families of homelessness. And then 2 years later, the state embraced that law, and it actually it built it into the social services law.
Thank you, Counsel. You have time. Oh, please.
Just let me
Please.
follow up with one question. As I didn't see anything in this record that the state weighed in on this set of laws. Is there anything in the record?
No, Your Honor, about this particular set, no.
Thank you.
Thank you. You have time in rebuttal. Counsel.
Sorry to interrupt you, Judge.
Good afternoon. Robert Desir for the Legal Aid Society for the Individual Appellants. The appellants represent low-income people in shelter and people at risk of homelessness, disabled elderly tenants facing eviction because of rents that exceed their income.
I want to address a question of remedy again. If we were to agree with the position shared by you and the City Council with regard to the merits of this and grant the mandamus that is sought by the Council, would there be still any need for a determination as to class status?
At that point, the city would be presenting a plan to the state to implement the directives of the legislation, and we wouldn't need to pursue further relief as we initially did in this case.
So if we were to grant the mandamus relief, then there would be no need to grant your request for class certification. Is that right?
correct. That's correct. The laws would be on their way to implementation, and that would satisfy the claims that we raised here today. So the city theft reform laws that extend rental housing assistance to housing insecure New Yorkers like the appellants only furthers the state policy of preventing evictions and homelessness. The lower court incorrectly held that the state's delegation of authority to the city preempted the council from setting policy to address housing insecurity via improvements to a city-funded rental assistance program. Because none of the reforms disturb the state's authority over local initiatives, this matter actually concerns the separation of powers at the local levels.
Sir, I'm sorry to cut you off, but in your experience in addressing issues of housing insecurity, have you run into a situation before where the New York City Council passes a local law and then the mayor relating to housing insecurity, and then the mayor refuses to implement it?
Well, we have run into situations where legislation has been vetoed and they've gone through the regular process, and where there's a disagreement, the executive takes action to enforce their position, but we haven't seen an instance where there's been just a decision that the law, duly passed law, was not going to be enforced. So,
And I'm curious, at the hearings at the City Council with regard to these laws, which I assume were held, did the mayor's office ever assert preemption or anything related to that at that time?
the mayor's office did speak out against the legislation, and in subsequent conversations, they
No,
did.
but did they specifically assert preemption as an issue at that time, at
They
the
did.
hearings?
Maybe not asserting preemption specifically, but definitely saying that, asserting their authority as the social services district and to the exclusion of the city council, certainly teeing up a preemption argument that we see here today.
Okay.
So because of none of the reform laws disturb the state's authority over local initiatives, as I said, this concerns separation of powers at the local level. As such, the council acted within its powers under the New York State Constitution, the New York City Charter.
So is it correct also that the city is spending its own money on these, pursuant to these local laws? Or is there going to be, does it imply further state funding?
Well, that the city is spending its own funding removes it from, a little bit removes it from the argument that they are operating solely under state law, and moves us towards further towards the separation.
But that factual premise that I just made is correct, that it is the factual premise that it's city's money being spent pursuant to these reform laws. Maybe that's a better question to put to the council. I'll ask them.
Yes,
Okay.
the City FEPS program is almost entirely, and I believe entirely, city-funded.
Okay, thank you.
So the argument that the state law privileges the mayor's initiative over that of the city council undermines the separation of powers guarantees. Just like the mayor, the local commissioner is accountable to both the city council and to the state. The city council's oversight over local DSS is derived from its role as the legislative branch of the social services district and from DSS's obligation to follow both state and city law.
And does the failure to enforce the law also undermine the city's home rule rights? Since that's in part accomplished through what the city's legislature, the council, does?
Well, in this instance, in order to get the relief that the appellants are looking for, the rent relief that they're looking for, they were forced to take action and bring the suit. The obligations of the city when these laws were passed go beyond the city and implicate the state, where they have to submit a plan for the state's approval. So it's not self-affecting, and there are other steps that are required. So I would say no to that. So as I said, the mayor is accountable to the council and the state. The council is part of the local social services district, and this essentially ensures that the council's role in overseeing the administration of social services within New York City. So the council can't unilaterally exclude, the city can't unilaterally exclude the council from passing laws to deal with benefits and rental assistance.
Thank you, counsel. You have time in rebuttal. Please.
May it please the court, Devin Slack for respondents. These local laws make changes to the administration of public assistance
We know
within
that.
city
The
limits.
question is it in an area that is preempted? And I'd really like you to focus on that.
I think I would, because if we,
Excuse me, because as I understand preemption, you have to show that the city, you've essentially made two arguments. One is that only the city DSS is the social service district, and you also argue that this is an area that's preempted. But I have trouble understanding the preemption argument, because it seems to me that under the 18 NYCRR 352.3, subdivision A3 little I, specifically is based on the possibility that social service districts would provide supplements and then submit them to OTDA. And that my understanding is that what the city council is asking is that the mayor make that application to OTDA with the package of bills that were passed. So I have two
Correct.
questions. Why doesn't that indicate that it's not preempted, because it in fact is something that is foreseen, that a local agency will ask for additional opportunities? And secondly, why hasn't the mayor done that?
I mean, I think the direct answer to your first question is that there are all kinds of schemes where there are preemption, where local variance is allowed, but there are state controls and mechanisms,
But nobody
coordination.
disputes that the state, I mean, the council for the city council said that they anticipate that what would happen if they win is that the city DSS and/or the mayor would submit this package of bills to the state for their approval. So no one's saying that it should happen unilaterally, right?
No, I think
Why wouldn't that be the right next step?
I think the problem is that runs up against the very specific provisions of the social services law that
What
tell us.
provision of the social service law does that run against? I couldn't find it in your brief.
I'll give you
And
three.
I'd really like to know exactly
I'll
what,
give you- I'll give you
excuse
three.
me, I'd really like to know exactly what provision of the social service law you think it runs up against.
Three. The first one is the power that I described at the beginning, the power to adopt local laws to make changes to public assistance within the city was once a power that the city council held. The state legislature eliminated that power
When?
in 1946 with the Ostertag Act.
So you're saying that since 1946, the city council has had no authority to enact legislation with regard to social services?
With regard to public assistance.
Well, does that
Second
rise or
piece.
fall on whether we agree with your interpretation of what is a social services district?
It does not, because in the same act that the state took that power away from city legislatures, it created the predecessor of what is set now today, Section 23A, which gives local services officials, that's the city commissioner, the power to make regulations regarding public assistance. That's a meaningful power. That's a powerful to regulate. And what the council
Well,
is
that's the
saying,
power to, most administrative agencies enjoy the power to promulgate regulations. We're talking about legislative power in that local law making.
most regulations, well, let me just get to the third piece, and then I'll circle back to this. The third piece is that other provisions of the state law are very specific about the limits of local lawmaking. There are provisions that say that there are these narrow pockets of authority, like Section 77, where the city council can weigh in on things like the department's staffing and structure. If the city council had plenary authority, those provisions would be superfluous. But I think the answer to your honor's question is that this isn't a regular administrative agency. The entire scheme that the Court of Appeals has told us is that this is a single state administrative agency where local services commissioners act as part of and arms of the state. There is, as the court told us, Court of Appeals in Baudouin, there is an inextricable, interconnected chain of authority that runs from local commissioners to the state commissioner. And the last thing I would just say is that—
But they're not disagreeing with that. I don't understand how that
I think
gets you where you want to be. There's no dispute that local commissioners are subject to state commissioners. The question is whether or not the city legislative body can propose laws which the mayor is required to bring to the state DSS as a proposal for a form of local rental assistance. So I don't see that you're answering that at all.
I agree that's the question. I would put it slightly differently. I think the question is, can the legislature basically displace the local commissioner
No,
by
I don't
dictating the
think that's the
policy?
Does it
question
have
at
to be
all.
displaced? It could, I'm sorry, you're
go ahead.
probably making the same
ahead.
point I am, which is that it's an augmentation, it's not a displacement.
Oh, I disagree. This is a fundamental transformation of City FEPS. There's no dispute about that. City FEPS was created by the City Department of Social Services, approved by the state. The City Council had no role in its creation, and that authority was exercised under 23A, which gives the commissioner, not the district, no one else, the commissioner, the authority to make regulations.
Which section is that?
23A.
But why can't the legislature, upon looking at how FEPS has operated, in fact, say, no, the cost of living in New York is greater, or whatever reason they have, and we propose these other changes to FEPS?
I think that would have been a perfectly reasonable way for the state to set up its state social services program. It's just not the way that it did it. It created local services commissioners and officials that are the arms of the state, report directly to the state.
You seem to be writing out of your analysis local social service districts, which are different from local social services commissioners. And in New York City, the social service district is the city of New York, which includes both its administrative aspect and its legislative aspect. Part of its administrative aspect is the City Department of Social Services.
No, I mean, we embrace that definition completely. I think the problem is that the petitioners have not grappled with the provisions of the social services law, past and present, that tell us who exercises what authority within the
I
city.
think they've been very clear. What they said they are asking for as a remedy is that the mayor or city DSS make a proposal to the Office of Temporary and Disability Assistance consistent with the 4 local laws which are now at issue. That's what they're asking for.
Exactly, and there are multiple
What's wrong with
statutory
that?
problems
What's
with
wrong
that.
with that?
One of them is that is making changes to the
No, it's
administration.
not making changes, it's proposing changes. That's different.
It is, Your Honor, respectfully, it is dictating changes.
No,
The
it's
council-
requesting, I'm sorry, that's why I specifically asked council that earlier. And what they are asking for is that those be presented to state DSS as a proposal, not as something that must be done or shall be implemented unless,
Sorry, I'm talking about something different. It is dictating what the city commissioner must put in regulations.
Which, by the way,
Section 23A
is the
provides.
way government normally operates. The legislature dictates to the executive branch, and then the executive branch agencies implement the policy reflected in the legislative prerogative. And we've turned, where it sounds like in this unique universe, we're turning that on its head.
It is a completely unique universe where the state creates a single state administrative agency.
And so if it's so special, why wouldn't the legislature make it plain what it was displacing was the policy-making authority, not the administrative, because policy and administration are two different things, which I think harmonizes the different definitions in the social services law regarding social services district on the one hand and social services department on the other.
Two things. First is, I don't think that is a correct distinction. When the legislative scheme talks about the state's authority, its policy-making authority, it's talked about in terms of administration. So on page 10 of our brief is cited a memorandum that talks about when the state commissioner office was created, he was given full authority over the administration of social services. That was seen as a policy-making authority. And the other part about it is that it just is a different scheme, as the Court of Appeals told us in Bedoin, in Thomasell.
Bedoin has nothing to do with this case. That is not a preemption case. It has no bearing whatsoever on this case.
I think it has bearing in the extent that it recognizes that this is a very unique
That
statutory
recognizes
scheme.
that a local social services agency must follow the results of a fair hearing, essentially. That's sort of, which is ordinary administrative law. It has nothing to do with preemption or any of the issues in this.
I'm not arguing it's a preemption case. I think that in both Thomasell, which was about the respective responsibilities of the state and the city, talk about the fundamental nature of the social services program, in which case it is different from your normal administrative agency that reports and is part of just city government. It is part of the state.
I'd like to go back to my earlier question about what part of the social services law you claim is in conflict with this procedure. You cited the 1940s legislation, the Oysterhag legislation. Where is that codified in the social services law in a way that conflicts with what is being proposed here?
Well, I mean, I think it's two pieces.
Where is it codified in the Social Services Law Council?
It's two pieces together. It's 23A, because in the Oysterhag Act, what the state did is it eliminated
23A of what?
23 of the social services law.
Okay.
In the Oysterhag Act, the legislature did two things. Well, it did a lot of things to create a new state local welfare setup, but it did two things relevant here. The first is it took away the power that city legislatures once had, quote, to adopt local laws to make changes to the administration of public assistance within city limits. It eliminated that power specifically and deliberately as part of a change to the local state welfare setup. In the same act, it created the predecessor to 23A, which recognizes that it is the authority of local social services officials. Here, that's the city commissioner, to make regulations about public assistance. That is a shift of policymaking authority from city legislatures to local officials, and that is consistent with this scheme, which is one where local commissioners act as part of and arms of the state.
So, sir, if we agree with your analysis, does that place the power of the purse strings with respect to social services spending in the hands of the mayor?
It does not. The social services law requires the city council, Section 88 requires the council to fund state programs.
But if the mayor's office drives the policy, wouldn't that dictate the appropriation that's needed for a given year?
No, I don't think so. I think that's done through the appropriation process.
So the city council could flip the script and say, we don't agree with this particular policy, so we're not going to make an appropriation for that line item.
They could try, but Section 88 requires them to fund the state's social services program. If you look at Bedoin, one thing it also says is that no matter what the source of the funding is, federal, state, or local, the important thing is that it all goes to the state program. The source of the funding doesn't tell you anything about the nature of the program.
Any other questions? Thank you, counsel.
Thank you, Your Honors.
Honors, I have a number of points. I just wanted to confirm, yes, City FEPS is funded through city funding, and yes, the Home Rule Authority is really the center of this case. I implore the court to look carefully at the legislative history because it proves our point. There's a portion of it in 2179 of the record, and the council is happy to provide the other bill jackets and special memoranda. It draws out very clearly what the state has been doing over the decades. There's a distinction between how social services officials need to administer state and local funding and policy making. All of the legislative history talks about these officials and how to make sure that the state is in conformity with federal law, addresses welfare fraud issues. There's not a single reference about local legislators that need to be reined in because their policy making is out of control.
Do you agree that Social Services Law 23 is dispositive in this case and removes the authority from the city council to do anything in this area?
Not at all, Your Honor. There are multiple references to local lawmaking and the social services law. The Ostrich Act removes one reference because there are multiple references. And I think what's really interesting about the legislative history of that act, and again, within the legislative history given to us by the council, there's a reaffirmation of Section 56. So within the legislative history that the mayor provides, it reaffirms that city social service districts have lawmaking power. That's Section 56, which has been in the Social Services Act since 1929, amended multiple times, but never the local lawmaking power has been removed from the city of New York.
Would that apply to individual counties as well as to the city of New York?
The city of New York is special. The legislative history really sets forward that it was constructed in this way for counties to, rural counties were not providing proper services, and so the idea was the state was going to issue a minimum, but there was a lot of effort because there was already local lawmaking for almshouses in 1929, and everyone wanted the city of New York and a few other municipalities to continue to have the authority to spend their money doing local innovation, and so that's why they created the city structure. So it's always been there from the beginning. And I would also just mention that if Your Honor is completely right, this is flipping the traditional role of the agency and the policy making. And if there was such a flip, you would expect to see it in the legislative history, and there is not an ounce of that. I would also add that Section 77, which my colleague said, proves that the social services district is not the city. It would be superfluous. What the state is doing is it's saying, local legislative bodies, you have, in addition to your plenary authority, there are a few things you can do. For one, you can take all of
You make that point very well in your brief, I think, Counsel. Thank you. Is there any other questions? Thank you very much. Counsel? We have one more rebuttal, yeah.
Just 3 points I want to raise really quickly. The case of Hernandez versus the city of New York is very instructive. It shows that legislative initiatives can come from the legislative branch, and that state control does not necessarily prevent localities from addressing specific local needs, just like the council did here. And as we've seen in New York State Affordable Association for Affordable Housing, this court found that even where the state delegates power to a city agency, the council can legislate as long as it doesn't conflict with state law. Lastly, speaking to Baudouin, we agree with the court's characterization that it doesn't apply to this situation here necessarily, but also wanted to point out that this case applies to county commissioners, where the social services law characterizes them differently as city districts, and says that in the case of the county commissioners and the county districts, there's language that says that the commissioners act as agents of the state, and that language is not present where the city is discussed.
Is it a distinction without a difference in this unique area of the law to talk about policy versus administration? Is it all really under the same tent? And if it is your friend correct that it belongs under the Department of Social Services tent?
The State Department of Social
The
Services?
city, I'm sorry, the city.
Well, the social services law and the charter all speak to the power of the city council, whether it's as a legislative social services district or whether it is as a legislative body. As has been mentioned, there is mention of the city council as the local legislative body in the social services law. And in addition, the social services law speaks to the actions that can be taken so long as they comply with local law. So all of that speaks to the inclusion of the city council. And we think that they acted properly in passing these laws to prevent eviction and homelessness. And we urge reversal of the lower court's decision.
Thank you very much. Thank you all. Next case is People versus Ortiz. Give us a second, counsel.
They don't seem to want to stay for my argument.
Okay, you may commence.
Thank you. Good afternoon, Your Honors. David Clem for Jason Ortiz. A little over 3 years ago on a cold winter day, Mr. Ortiz went into a Gap store and left with a jacket valued at less than $200. That petty larceny was escalated because a store employee stepped in front of him and he pulled out a box cutter and threatened that employee. No one was injured. He left with the coat. And 3 years later, he's still in prison for this offense.
Sir, could you address Mr. Ortiz's prior criminal history?
Or he has one prior felony, the lowest level felony from 2021 attempted burglary 3. He's got 5 prior misdemeanors that date back further than that for simple drug possession or petty larceny, and then 1 out-of-state misdemeanor as well.
And did any of those priors involve a weapon?
The record doesn't reflect that. The only possible one, given the nature of them, would seemingly be a 2003 Pennsylvania simple assault case. There's no indication it involved a weapon. I presume it's the equivalent of the New York simple assault case.
When you say simple assault, you mean a misdemeanor?
A misdemeanor. I mean, it's a Pennsylvania crime, so I'm not entirely sure of the equivalency, but it would be the equivalent of New York's misdemeanor assault.
I'm curious whether the judge's allocution at sentencing or his explanation of a waiver of the right to appeal took into account in any way the fact that Mr. Ortiz apparently has a history of schizophrenia and bipolar disorder.
No, it did not take that into account, but I think there's even 2 more basic fundamental flaws with the waiver here. The first is the court completely made up its own charge. It wasn't following the CJI charge on the waiver. And it says, and I'll quote it, "If you can't afford the cost of an appeal or a lawyer for the appeal, the state would pay for both of those things. We're fine, okay." It's the very next sentence. "By pleading guilty and signing the waiver of appeal, you are giving up all those rights."
Right.
Just fundamentally flawed. That's one. The second major problem here.
So would that imply that the defendant, or make him think, you think, that by appealing his conviction, it would be pointless because he would not have an attorney?
Yeah.
That's what the implication is that you're saying. He would,
Yeah, that's the
inference that he would draw.
Yeah, I think it's even clearer than an inference. The court explicitly says you're giving up those rights. Not accurate. And of course, as the Thompson case from the Court of Appeals points out, you can't tell a defendant that and have that waiver be enforced.
So he pled guilty to a D felony,
Yes,
and the maximum is 3.5 to 7.
yes,
He got charged with a robbery in the first degree,
correct.
which the maximum was what, 25?
25,
And he received a sentence of 2.5 to 5.
yes.
So how is that excessive?
just looking at the nature of the facts here, which we went over, those are all the facts. Putting someone in prison for up to 5 years for that is simply too much time. And it's made worse here, given his mental health history and how much more difficult prison makes, and his record, the only felony brings up that sentence.
Thank you, Counsel. You have time in rebuttal. Thank you. Oh, pardon me, actually.
I have one more
Judge
question.
Gesmer has a question.
How, if at all, is your argument in this case affected by the recent Court of Appeals decision in People versus Brisman?
I don't think it's impacted, other than that this court clearly has the authority to go and put in place the appropriate sentence, which is 2 to 4 years here.
Thank you.
Good afternoon, Your Honors. May it please the Court. Connor Burns for the People. The defendant did validly waive his appeal, which would preclude review of his excessive sentence claim, but in any event, his near minimum sentence was not excessive. Just briefly on the appeal waiver.
Do you have any concern about the fact that he described rights and then said, but you're giving those up, and that could have been understood to mean that he was giving up his right, for example, to have counsel on appeal?
I believe the judge misspoke. I belive when looking
Well, misspeaking is a serious thing in
I
these
think
matters,
when you look
isn't
at the
it?
record,
I'm sorry, what do you mean by misspoke? How is a defendant to know which part of what the judge said was misspeaking and which was accurate?
so I think the further colloquy may have cleared that up, and I think, so the judge, even though they described the appeal waiver, still says that you can appeal for 4 distinct issues. The colloquy certainly didn't.
Does he go back to saying, and you would have counsel at that point?
He doesn't go back to that, but I think
So how would the defendant know that he would have counsel on appeal, given that the court said, after describing the right to counsel, then said, you're giving up all of those rights? Is there anything else he said that which would lead the defendant to understand he would have a right to counsel on appeal?
Well, I don't think specifically that, but I think it's our.
So isn't that a problem?
Well, certainly, and I think that's what we attempted to address in the brief. And again, by describing that, he would still be able to appeal despite the waiver. I think that would suggest that. And I think defendant's actions following the court appearance, he files a notice of appeal and requests assignment on appeal.
Criminal defendants with significant mental health histories aren't good at picking up on legal nuance.
Certainly, yes, and I believe, again, it was our position that based on the colloquy and the written waiver and his conduct after, it could be suggested that the court didn't suggest that. But I'll move to the merits of the argument.
Is there any evidence from a medical professional with regard to his mental illness and the effect that it has on his jail sentence?
Well, it was certainly noted in the PSR. I think the judge, during the plea colloquy, discussed the medication that the defendant was taking to address his mental health illness, but there was no 730 examination. There was no no information other than his own reporting of his illnesses in the PSR. So certainly
The judge would have had access to the PSR where it talks about the defendant's schizophrenia, correct?
Certainly, yes. And I'm just saying that's the only time it's mentioned. Again, there's no examination. Not to comment otherwise why that is. I'm just answering the judge's question as to that's the only information we have about the.
And that information would have been available at the time of sentencing as opposed to when he took the plea?
Certainly, it was. I don't know if the PSR wasn't available at the time of the plea, but the judge in her plea colloquy did ask the defendant about the medications he was taking, and he was forthcoming, saying that he is taking medication for his mental health illness, and then certainly the PSR was available to the judge prior to sentencing. And I think that and his criminal history and the severity of the crime, they all worked together to fashion the sentence that I think was lenient given those circumstances. Again, as the panel noted, he did face first-degree robbery charges. He was able to plead down to third-degree robbery, where he faced 8 to 25 years on the first-degree robbery, and he was only sentenced to 2.5 to 5 when the minimum was 2 to 4. So I think given his criminal history and the severity of the crime, even though no one was injured, it was still a violent act. And I think given that, his sentence was lenient.
So the aggravating factor here was pulling out a razor, basically.
Yeah, a box cutter was.
And threatening someone with it.
Yes.
Did he swing it at anyone?
The record doesn't reflect that, but he does say to the employee, if you come any closer, I'll cut you or I'll stab you.
And we don't know how far that employee was from him.
No, we don't know.
All we know is that he had a coat and he pulled out the razor and said, "Don't come near me," basically.
Correct.
Okay.
And if there are no further questions, we would ask you to affirm.
Thank you, counsel.
Thanks.
Unless the court has any follow-up questions, I just ask that you reduce the sentence to 2 to 4 years.
If we were to reduce to 2 to 4, how much time has he served already?
So he'd be eligible for parole at that point, having served, I think, just over 2 years in custody. And would still have time on, assuming he made parole release, which I would certainly expect, would still have time on parole after his release. Thank you.
Thank you. Case of Maurice versus Michelle.
Good afternoon, Your Honors. If it please the court, I'm Michelle Kahn of Kahn and Goldberg. I'd like to spend my time today addressing the latter 2 points of my brief that are the findings of unjustifiable conduct that the court below made regarding my client. First, the court found that my client misled the court in his application for an order to preclude the mother from removing the child from New York. And she found that the father improperly retained the child without the consent of the person entitled to custody past the, quote, agreed upon date. Couple of things I want to point out. First, and I don't think this point is made very clear in the brief, the findings I'm asking in this court to vacate and throw out are not findings of credibility. They're findings that the court below says that she found based upon the record, but the record itself
The
was
record
not.
includes the transcript and the testimony, and the court was pretty clear that it was making findings of credibility. So I don't understand why we should decide that one of her findings was not a credibility finding, to which, as you know, we ordinarily give a great deal of deference.
Right. But it was, I don't think she said it was based on credibility. I think she said based on what the father said in his application, and his intent, she said, was to keep the child past the June date. And it wasn't his intent because he made the application in October 2022.
I'm sorry, I'm still having difficulty understanding how you can decide that one of the things she concluded about the validity of what the father said wasn't based on credibility. It seems to me that when a trial judge makes findings of fact and has also made findings as to the credibility of the parties, that finding of credibility affects how the judge interprets all of the testimony that the judge has heard.
Because she's relying on things in the record that just aren't in the record. So, for example, the father in his application.
How do you know that she's relying on something which was not in the record?
Because she says that the father intended, by making his application, to keep the child past the June 2023
Why
date.
isn't that an inference she can draw from the testimony?
Because a couple of reasons. One is the court granted the order, right, the no removal order, based upon the father's truthful testimony. He was not in any way untruthful with the court. He said the mother said she was threatening to remove the child to California and keep him out of her life, and he said that he was worried that she had threatened she was going to take him to court for custody. So he wasn't saying anything untruthful.
But that did not come to pass. That didn't happen.
Well, we also argue.
So couldn't she draw the inference this was an ex parte application, that he hadn't been square with her and hadn't told her the truth?
But he had told her the truth. In court on October 18th, he said the mother was here. The Friday was the day he sought the order, and Monday was a court appearance. And on Monday, he said to the court, the mother was just here and she left. And I said to the court, the mother comes here once a month and sees the child. And nobody said she took the child. It never dawned on anybody to say she didn't take the child. And then I see I'm not ringing a bell here, but I would like to point out that the court below said that the father kept the child away from the person entitled to custody, and retain the child past an agreed upon date. I want to point out a couple of things to the court. One is that right after we brought the application, we asked the court for an expedited finding on jurisdiction. So we weren't looking to, or the father wasn't looking to, have this case go on for the 13 months it went on. He figured he was going to make an application. He asked for the order. The court was supposed to determine jurisdiction under DRL 75F, I believe it is, on an expedited basis. That didn't happen. But just because that didn't happen doesn't mean that the father was somehow trying to game the system. And he wasn't. And part of the proof is that he asked that the court deal with this on an expedited basis. The court also found that it had the effect of keeping the person who was entitled to custody away from the child, but there was no prior order that the mother was entitled to custody. Nobody was entitled to custody.
The party's agreement had been that the child would go back to California in January, and that was why the child was enrolled in daycare in January. And the effect of what your client did was that the child did not go back to California in January, right?
Actually, I think the child was enrolled in daycare in California the prior January, not January 2023, and the child was enrolled in daycare in New York. He did ask the court to prevent the mother from removing the child from New York, but it wasn't his intention, and there's nothing in the record that shows it's his intention to try to keep the child past the June date. We brought the case in October and asked that the court make an expedited decision. Nobody thought
Counsel,
it was going to take 13
you made that point
months.
previously in your brief very well. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. Brianne Kopp for the respondent mother.
Could you address the issue that counsel was raising with regard to whether or not the father's intent or not with regard to keeping the child with him as opposed to with the mother?
Just the last.
With regard to keeping the child with him at that time.
Sure. The appellant is reading intent into the decision where I actually don't see the court ruling on the father's intent there. The court does say that his misleading the court in the initial application had the effect of keeping the child from the mother during what would have been her parenting time. That time that she's referring to is actually a factual finding that she found during that fact-finding hearing. So the court found during the fact-finding hearing that the parties did have an agreement that the child would be returning to the mother at the end of the father's year. So that time that the mother lost out on was essentially June 2023 to November 2023, at which point the judge had modified that order on an interim basis prior to receiving the final decision on the jurisdictional issue.
Did the petitioner, the father, at any time acknowledge that his statement that the child would be imminently removed from the jurisdiction was not true?
He did, during cross-examination, acknowledge that there had been no real danger that the child would be removed from the jurisdiction that came to pass. So on cross-examination, he acknowledged that at the time he filed the petition on October 14th, it was prior to the mother's weekend. She had the child without incident over that weekend prior to the appearance on October 18th. Did not inform the court expressly that the mother was there, returned the child, although she had no knowledge of his petition or application, without incident. So the fear that the mother would remove the child or abscond with the child to California did not come to pass in any way.
Isn't it the case that the child did not live in New York for 6 months prior to filing the application?
Absolutely. It was acknowledged essentially from the beginning that New York did not have home state jurisdiction because New York had not been the child's residence for 6 months prior to the petition. There is actually essentially a typo in the decision because the judge does several times say 5.5 months that the child had been in New York, but it's actually 4.5 months prior to the filing.
Any further questions? Thank you, counsel.
Thank you.
Thank you. The father did not admit during cross-examination that there had been no emergency. He continued to say that the mother had threatened to take the child back to California and cut him out of her life. And I know that it didn't come to pass that weekend, but you know, I think of the doomsday clock, and you know, we hope that doesn't come to pass, but it doesn't mean there's not a real fear that something may come to pass. And he never misled the court. He said what the mother had said to him and why he felt that that was a threat. And
The mother never acknowledged having said that to him, right?
I believe that's correct, the first thing. I think she acknowledged saying the second thing, that she would take him to court for custody, which was the second thing he said. She never acknowledged saying the first thing. But the point being is he didn't mislead the court.
Well, unless it was not true, which is what the court found.
But again, just because it didn't happen that weekend doesn't mean the mother...
Excuse me, when one party says one thing and the other party says the other thing, and the court has the opportunity to see them both, the court makes a credibility determination, and apparently she concluded that the father was not credible on that issue and that he was making a false statement.
I think that's reading a lot into the decision, Your Honor. I think, again, she's saying that the judge below is saying that she was misled because nobody told her on October 18th that the mother had visited with the child and not absconded with the child. And if you look at the record, it's pretty clear that although she wasn't expressly told that, she was told just about that, and she would have been told if the mother had taken the child. So that's the that's the factual thing in the record that's just not true and just doesn't support the findings.
Thank you, counsel. Thank you
you.
both. In the matter of the application of Ling Lin,
Good afternoon, Your Honors. May it please the court, Chet Lukaszewski for Petitioner Appellate Lin. Your Honors, I understand Article 78, and deference is afforded to the agency from the judge. Get it. Borenstein and Meyer, Court of Appeals, deference is afforded to the medical boards. Understand.
You're asking us not to do that in this.
No, Your Honors, I'm asking you not to forget that the Court of Appeals also handed down the Brady case and said a full and fair and painstaking review of all facts and evidence has to be administered. I'm asking you not to forget the Tobin rule that says if there is a contributory effect from the line of duty injuries, then the disability, if found to have been exacerbated to that point, is a line of duty disability.
so that's how you get around their argument, the other side's argument that the petitioner's physician never really addressed the 2011 diagnosis of degenerative disease.
Your Honors, that's exactly it. They're putting blinders on, and they're saying the July 2015 MRI and the October 15 MRI are the same, so the injury in July and October don't matter. Well, what about the first four? What about the three that led up to him having this degenerative condition at the age of 32 in the 2011 MRI? The first one, Your Honor, he had 3 line of duties before that, 3 traumatic back injuries. So he's 32 years old, he's a slim person, he's fit, he's been on the job 4 years, he has these 3 injuries, and that's the first indication of the degenerative disc disease.
And is there any medical proof that the line of duty injuries caused the degeneration?
Your Honor, how can I prove that? That's what's unprovable, but that's saying every single factor indicates that he's had 3 traumas. He's a skinny, healthy person. There's the onset of DDD, very minimal in 11. Then he gets violently assaulted in I want to be sure. Then he gets violently assaulted in 2012. So much so, Your Honor, that he has to have spinal surgery at age 34 on L5S1. Every single MRI in this span, and this is just like your Baudère case, it shows that where there was degeneration, there was bulges or herniations.
Well, do you think they had enough to, I mean, he then, after that incident in 2012, he then applied for ADR for the first time, is that correct? Was it the first time? Maybe not the first time.
No, Your Honor, it was after that. It was after the spinal surgery. And
I'm sorry, so the point of that question, or the premise is, so if he filed on September 14, 2012, that was denied. Should that have been granted at that time?
No, Your Honor. There was no judicial challenge. And again, this is before my involvement in this case. Once there was a denial, though, the lower court in Lin 1 said that the denial was improper. The finding of no disability is improper. And then all this new evidence of the continued escalation of the condition happens. He's deemed a spinal surgery fusion candidate. Then, once it's taken back on remand, the pension fund says, you know what? We were wrong. He was disabled as of July 15. So don't worry about any of that other evidence. We're going back to July 15, and then puts the blinders on and doesn't consider the factors that led up to the July 15 disability. The lower court did the same thing. All they looked at was the answer. They didn't look at what led up to that. Just like this court said in Baudère, you have to look at those other MRIs. You have to look at the factors where he has no predispositions. He has no other indications that could lead to this. This all adds up to, if you look to that July 15 and the line of duties and the MRIs, this is Baudère, this is Tobin, and this is Brady. It's not the broad protections of Borenstein and Meyer, which usually leave me here without a leg to stand on. This case fits your criteria.
What happened to the application that was based on a psychiatric diagnosis? Do you know?
Your Honor, that was before my time. They put that in on his behalf. I know he went to a center. From what I have read and what I have seen, he was over-medicated. He says he kicked that addiction, went back to work. The police department never fired him. They put him in treatment. And then again, on judicial remand. So the first time this court was before the lower court, they said it was arbitrary and capricious. We don't think you can find this person not to be disabled. They took it back, found him disabled, but picked the point in time of July 15. And when that point in time came about, the only thing the medical board then said was, well, there was no difference between July and December. They took out everything that happened before that point of disability, and all of that adds up to a disability that's causally related to these events. That's what Tobin is for. It's for the person who has multiple events and becomes disabled, rather than just getting thrown down by a perpetrator or getting hit by a drunk driver while in an RMP. They said if there's a causal effect, that person should be protected as well. And this court in Salvia, in Sigmund, in Baudère, in Barankowski, you have found that these broad laws don't stop you from stepping in when you can connect the dots, and we think you can here.
Thank you, counsel. Good time in rebuttal.
May it please the court, Pauline Essman on behalf of the city respondents. Supreme Court correctly denied Lin's petition to vacate the pension board's determination here. I'd ask this court to affirm. This court has indicated this case is not being decided on a blank slate here. There's a high bar to vacate decisions of the Board of Trustees, and that bar is particularly high when, like here, the Board of Trustees ties on the issue of whether to grant ordinary or accidental disability benefits. The result of a tie, as here to grant ordinary disability benefits, must stand if any credible evidence supports that there isn't causation between the disabling condition, which is here degenerative disc disease, and Lin's line of duty injuries.
He was pretty young to have degenerative disc disease, wasn't he?
You know, I'm not sure there's anything in the record that indicates when the onset of degenerative disc disease can occur, and there's next to nothing in the record about Lin's prior history. You know, he was, I believe, 28 when he joined the force. He was in his 30s when he was diagnosed, but that said, we don't know much about his prior history, and it's Lin's burden to show that there's causation here and to vacate the pension board's decision. And here, Lin can't clear that high bar. So Lin was diagnosed with degenerative disc disease in 2011 before all but 3 of his line of duty injuries. So at least as an initial matter, many of his injuries simply could not have caused his degenerative disc disease, though I recognize we have to show that they did not permanently worsen it as well. Of the 3 injuries that came before his degenerative disc disease, for one, he was only diagnosed with neck injuries and treated with neck injuries, not back injuries. The other 2, he was diagnosed with back sprains, which are damage to the ligaments, not a disc-related condition. Now, the board also looked at this in light of the fact that his condition was degenerative, which means it unfortunately was going to naturally get worse over time. And unlike in some of these cases where there aren't degenerative conditions, the board here could say by looking at the medical records and physically examining Lin that this was more consistent with a natural progression of degenerative disc disease than it was with being permanently aggravated or caused by Lin's line of duty injuries. And in particular here, it pointed to evidence in the record to do so. Its final medical board report, specifically at record 130 and 132, highlighted certain radiographic images and MRIs, and it said that from 2011 to 2012, those scans showed that there wasn't a significant progression in Lin's degenerative disc disease, though he did have a line of duty incident in that period. And it said the same thing about 2015 as well. Despite a line of duty incident, we didn't see a significant progression in his degenerative disc disease. Briefly, I want to address a point made by my colleague on the other side, which is that the medical board only looked at 2015. That's simply not the case. At record 132, the board is specifically discussing Lin's 2015 scans and 2015 injuries, but that same report at record 130 is looking further back at his other scans as well. Now, we certainly understand that there are possible other readings of the record, and we don't dispute that even a couple of Lin's doctors here linked at least some of his work injuries to his degenerative disc disease, but the board it's in its sole province to resolve conflicting evidence, to make its own readings of the MRIs.
Right, your argument is they didn't disregard evidence, they just weighed it differently than we might.
That's right, Your Honor.
We're not allowed to reweigh evidence before the board.
Yeah, so this board cannot, or this court cannot weigh the evidence. It simply must look to see if the board relied on credible evidence, meaning evidence from a credible source that reasonably supports the proposition, which here would be the scans.
Counsel, is there any explanation for why they denied ODR even in 2017?
Well, my understanding is that earlier they didn't see his condition as permanently worsening, or permanently preventing him from being able to do his work. So, for example, they saw that he was using a back brace at one point, and then they deferred a decision on his application directly before his the last decision when they said we want to see whether a spinal cord simulator will work. But yeah, the previous denials were based on just a finding that he didn't have a disability and therefore wasn't entitled to ODR.
Did the board doctors also examine this petitioner?
Pardon, the board did examine him 7 times. I'm not sure if that addresses your question, Your Honor.
Did they do a physical examination of?
They did. So there were 7 medical board reports. So each time that they issued a report, they physically examined him. They looked to see, for example, could he squat fully? Was his gait normal? By the time we reach the point where they do grant him ODR, they see that he can't do those things properly, and therefore they make a finding that he's disabled, meaning he can't perform his work fully, but they don't link that causally to his line of duty injuries. And if this court has no further questions, I'd ask it to affirm.
Thank you, counsel.
Your Honors, they examined him 7 times, but 4 of those were before the first court proceeding, when the lower court said the decision was arbitrary and capricious, that he's not disabled. So then they come back and they eventually say, okay, he is disabled, but it's 2015. And now we come here before the court, and if we were to bring a narrative in, a detailed narrative, they would say, well, our doctors are allowed to disagree with your doctor. So we say, okay, how about just commonly accepted medical theory, Mayo Clinic, Cleveland Clinic, normal age ranges, normal effect of trauma, normal effect when you see in this person in this age a traumatic herniation or bulge, and then it winds up in degenerative disc disease below the age of 40. So we can't win. If we can't bring a narrative, if we can't rely on common sense and the factual progression and diagnostic proof and commonly accepted theories,
Isn't that what
then
experts are for? I'm having a problem with the idea of common sense for medical information.
no, Your Honor, because if we brought an expert in who was to say this, then we would say, well, our expert's allowed to disagree with yours. So then what do? Do you bring an expert, or do you give the facts and you give the common sense medical theories of an age, no predisposition, an MRI that shows trauma, then an MRI 2 years later that shows in that area of trauma degenerative disc disease?
Thank you, counsel.
Your Honor, just one last thing. If you would just
No,
please
counsel,
read
time's up.
ODR
I gave you
before.
rebuttals. Thank you. Okay, Esterson versus Spring. Now, there's a cross appeal, so we've given you both 5 and 2 and 5 and 2. Counsel, remember there's a calendar call. Counsel, remember to show up at 2 o'clock. We gave you a courtesy by allowing you to argue. Okay, let's begin with the defendants. With the defendants?
Yeah, well, yes, really the appellant, Harry Spring.
Right.
On the cross appeal.
Please, go ahead.
Your Honor, I'd like to begin with a question. Normally, you folks ask us questions.
Yeah, we don't
My
like it when you
question
ask
is
us questions,
rhetorical.
usually counsel.
What in God's name did Harry Spring do wrong that would justify penalizing him and punishing him, making him responsible for 100% of a debt that was equally guaranteed by all three of them? He was the 70%.
Counsel,
owner
that
of the
ship has
company.
sailed, first of all. The guarantee is gone. We're talking about contribution at this point. right?
You're absolutely right about that,
Okay,
Your Honor.
so
with
instead
all
of
the
talking
law.
about rhetorical questions, give us your argument, please.
No problem. The law on contribution is very clear. It is equal. It should be 1/3, 1/3, 1/3, except if there's an exception. And the only exception is if one party benefited more from it.
Well, another exception is if one of the three parties is the sole owner, in this case, of WASA. Didn't he say that?
No, Your Honor,
Let me finish the question. In the bankruptcy proceeding, did he not make a representation that he was the sole owner of WASA?
Your Honor,
That's a yes or no.
Your Honor, in the bankruptcy proceeding, Your Honor, there was an.
I don't want to know about the context. I want to know what he said. Did he say that?
Well, Your Honor, there was no writing about it. There was never a transfer of
Did he
ownership.
make that representation in the bankruptcy proceeding, yes or no?
Well, Your Honor, if it's in the record, there was a statement, but Your
Counsel,
Honor,
it's your
there has
job to
be an
know the
agreement.
record.
There has to be
Counsel,
an agreement.
stop talking. It's your job to know the record and be candid with the court. Please proceed.
Your Honor, there was no agreement ever transferring ownership. What happened here is that,
You didn't answer the question, but go ahead.
well, there has to be an agreement to transfer ownership. Even if somebody says,
But the question was, did he make that representation in the bankruptcy court? You still haven't answered that.
We'll draw whatever inference we choose to from that. You can continue, counsel.
Thank you, Your Honor. Your Honor, the decision below was based on pure speculation, and it was based on pure conjecture. The trial court made assumptions, and these were business decisions that Mr. Spring made as a business person to keep the company open based on the advice of neutral bankruptcy counsel.
But Justice Cohen found no persuasive evidence that the money that was used to purchase the Citibank loan was in fact Mr. Spring's. What do you got about that?
Your Honor, it was this court itself held, Your Honor, that the money was Mr. Spring's. In the 2021 decision, this court said that Citibank was paid, quote, using funds provided by Spring. That was law of the case. There was no requirement to prove that point again, since this court had already determined it. But, Your Honor, there's even more than that. The money was paid during the bankruptcy. The bankruptcy court supervised every penny of this company, as did Citibank, because there was a use of cash collateral. Not one penny of WASA's money was used to pay it. It came from Harry Spring, as this court determined.
What evidence of that was there in the record?
The evidence was the bank. Well, first of all, it was law of the case. But the evidence was that it was paid in the bankruptcy, and the bankruptcy court approved every penny of WASA's money. If WASA had any money, it would have been paid directly from the bankrupt estate to Citibank. There was no money. That's why the company went under, and it was pure speculation for the trial court to assume, just simply to assume that it was paid by the company. There was no evidence of that.
Why weren't the bank records produced? Why weren't there any bank records with regard to the payment?
Well, Your Honor, what was produced was the assignment, and the assignment it recited all of the steps. Citibank would not have given up its huge claim of over $1 million unless it was paid. So clearly, Citibank paid it, and this court determined that the money came from Harry Spring.
We did?
And
This court did?
This court did, yes.
Well, I have the decision from this court here with me, and this is what the relevant section of the decision says. Spring, as a co-guarantor, may recover against the co-obligor partners only by means of a cause of action for contribution, which you're trying to do. As a result, Spring will be able to recover from the co-obligor partners only to the extent he can show he paid in excess of his proportionate share of the debt. Spring acknowledges having used his personal funds to purchase the Citibank debt. Accordingly, his creation of HSC as a vehicle by which to effectuate the purchase does not affect our determination. So I don't think that we specifically held that you use your own funds.
But what about the sentence that says that HSC, Harry Spring Company, which Spring formed for the purpose of purchasing the loan, paid Citibank the full amount of the loan debt in exchange for an assignment of the loan using funds provided by Spring? That was law of the case.
That's your argument. That's what you argued, and that's what we found that you argued. But then we didn't hold that that's exactly what you did. That's not what we held.
Well, Your Honor, then we look at where did the money come? Look, the money
That's
didn't
what
come-
you have to prove below, which is what the court found you failed to do.
No, but it was proven.
Counsel, you
through
have
the-
time in
the
rebuttal.
records
Thank you.
of the bankruptcy.
Thank you, counsel. You can sit down.
Good afternoon, Your Honors. May it please the court, Charles Kleiner. Unlike my colleague, Your Honor, I will answer that Mr. Spring did represent to the bankruptcy court that he was 100% owner of WASA.
Is it law of the case that we held that Mr. Spring had used his own funds to buy the Citibank debt loan?
No, it's not.
It's not, right?
No, I disagree with that position. As Your Honor had picked up, there was no evidence before the trial court that showed that Mr. Spring used his own funds directly or indirectly to pay Citibank. If I had a debt and I was paying the debt off, I wouldn't form a consulting company all of a sudden to pay a debt, and I would have a record showing money going to that consulting firm and then paying off the debt. Mr. Spring has nothing. He has no financial records, no bank records. When it's to his convenience, information is missing. When it's to his advantage, all of a sudden he can show it. And that leads us to our portion of the appeal, Your Honors, and that was the issue of spoliation, where Mr. Spring did something that I could say I've never seen before in all my years of practice. He represented to the trial court and to this court prior that the financial records of WASA were destroyed because of some computer virus and something beyond his financial, his computer.
That did happen, right? There was, I mean, to your satisfaction, wasn't there indeed some ransomware that did that?
There was no destruction, though, Your Honor. They had backup
were hard
servers,
copies.
and they had these records, and the records came out on trial by their IT person that records were copied and provided to a different attorney that was representing Spring and WASA.
So there was a computer virus, but there was another copy of the record. So
That was correct. Yeah, it was to his advantage to state to this court that the financial documents were destroyed because we couldn't prove our claim for damages or what receivables were taken in by WASA and used to pay down any debt whatsoever. Of course, he custom made it that we would fail, Your Honors. And he shouldn't benefit from that, Your Honors. Again, and I think that the court I know is loath to award attorney's fees and sanction attorneys, and I respect that. But again, in this situation, I think the Rule 130.1 is so applicable. I can't think of another situation where this whole case, the trial, the appeals, would not have taken place if Mr. Spring was honest and forthright with respect to the financial records. He wasn't, and he shouldn't get away with it. We would deny our cause of action for breach of contract and breach of fiduciary duty because we can prove damages.
It is an abuse of discretion standard concerning sanctions, however, you agree?
Yes.
And so, and you're arguing that there was an abuse of discretion?
It was an abuse of discretion,
All right,
Your Honor.
thank you. Is there anything else?
No, Your Honor.
Anybody else? Thank you.
Your Honor, if I may, it is undisputed that a year earlier, on March 2016, Harry Spring authorized the full financial information to be delivered to the computer consultant for Pamela Jerome. That is undisputed. Both computer consultants testified to that at the trial. They had all of this information several years earlier. And so for them to claim that they didn't have it, that they didn't need it, when it was undisputed that they had it in March of 2016, that is in the record, there is no dispute about that. But let me also add, Your Honor, in terms of what was cloned or another one, there was no testimony about what was on that disc, who gave the disc, when the disc was given. There was just a snippet. One of the consultants said, oh, some disc was given. Nobody knows what was on the disc. Nobody knows whether anybody can even open up that disc. Look what Harry Spring...
At the time when you disclosed, when you went to the court and said these records were destroyed, did you also acknowledge that at least a snippet had been copied and were available somewhere?
They were not available. The problem is we attempted to get them, and the lawyer who it was allegedly sent to said he doesn't have it and could not produce it. But Your Honor, spoliation requires a culpable mind. Harry Spring gave them. He gave Pamela Jerome the laptops. Harry Spring gave Pamela Jerome the file cabinets to take. He didn't sue when they left. Is this someone with a culpable mind who should be penalized for spoliation damages? Nothing nothing that he did fits in with that. And what the spoliation defense is, it simply was an attempt to distract the court. To go, what's a good defense to go on the offense? And that's all that it is. And the lower court at least got that one right. And you're absolutely right. It was in an exercise of discretion and denied spoliation.
Thank you, counsel.
Be brief, Your Honors. It was the IT person for WASA who testified at the trial that it was the financial records on the disk that was transferred to the attorney for WASA. What was provided to Ms. Jerome and Mr. Esterson was not the financial records, but other information that WASA had that with respect to their practice of architectural work, but it wasn't financial records. So Mr. Spring and counsel are being disingenuous to this court when they could represent that the financial records were provided to us. If they were provided to us, we would have been able to produce and show our claim for damages in this case. They weren't provided. None of those records, hard copies, were ever presented to the trial court. If they were provided, why weren't they presented at the trial court level? Mr. Spring could have easily produced copies, said, listen, this is what I produced. Instead of just walking the walk, talking the talk, he could have walked the walk, but he didn't because there were no financial records presented. And he misrepresented himself to this court in an earlier appeal, and that he got hoisted on his own petard when he tried to claim now, oh, yeah, there was a disc, but we just discovered it. On the eve of trial, it was just discovered. Thank you.
Thank you, counsel. Thank you both. People versus, Dar versus Saj Transportation. Please.
Good afternoon, Your Honors. Carl Zaffe from the law firm of Halden Hines. Pleased to be here today representing defendant appellants. As Your Honors are aware, we're primarily arguing that the lower court made three reversible errors, one with regards to various subpoenas that were issued, two with regards to the dismissal of the second third-party complaint, and three, the denial of our motion to dismiss the complaint. If it pleases the court, I would like to start with the...
I mean, I'd agree. I think we all agree that it's not the case that only the targets of a subpoena may move to quash, so you don't have to dwell on that.
But I wasn't going to do that, so thank you for getting that out of the way regardless. I was actually going to start with the dismissal of our second third-party complaint. The court, oddly, in our opinion, found that there was no contract, and therefore they dismissed the breach of contract claim.
So what contract are you claiming was signed by SAJ? Because in order for SAJ to assert a contract claim, there has to have been a contract signed by SAJ. And I couldn't figure out what contract you were claiming was SAJ was a party to.
Of course, paragraphs 63 and 64 of the second third-party amended complaint refer to the contracts in question. I believe it's referring to the operating agreement and then the transfer agreement that was subsequently entered between Zahid Dar and Salman Dar.
But SAJ wasn't a party to either of those.
Well, it was a party vis-à-vis the members of the
But,
contract.
so it can't sue if it wasn't a party to the contract.
Well, it's our position that it can sue based on that contract because the members of the LLC signed it on
Do
behalf.
you have any authority for that?
I believe there was some authority cited in our brief, but I mean, it's our position essentially.
You agree that SAJ was not actually a party to either of the contracts on which you were suing for breach of contract?
I would agree to the extent that an LLC can't technically be the signatory of a contract because it doesn't exist. You need a member to sign for it on behalf of the LLC.
Right, but in either of those, were either of those contracts entered into by a member on behalf of SAJ?
My recollection is that they were. In any event, if you get past that, obviously.
It's a big thing to get past, but go ahead. If there's no contract, that's a big problem.
Our position is there is a contract. Obviously, the court may disagree, but our position is that they entered it on behalf of SAJ. That being said,
Yeah, let's say we find that there was not a contract, but doesn't that mean that then the other causes of action are not duplicative of a contract claim because it's been knocked out of the case?
absolutely. So if there's no breach of contract claim, if the breach of contract claim has been dismissed, then the lower court dismissed all these other causes of action because they were duplicative of the breach of contract claim. If there's no more breach of contract claim, then obviously that rationale disappears, and all those quasi-contract claims, the additional claims such as unjust enrichment, et cetera, can come back in because that was really the sole reason why the judge dismissed those. With regards to the fraud and misrepresentation claims, the judge dismissed them because, in his opinion, they weren't specific enough. He specifically cited a case that to appellants appear to be a defamation type standard where you have to say the name of the person, what was said, the specific date, et cetera. It's our position that the case law that analyzes the details needed for the pleading of a fraud claim basically just says that you have to put the defendants on notice as to the substance of the claim. We feel that
In your conversion claim, you've got the sons involved, but how is Aman, the son, involved?
there are two specific causes of action, two specific complaints cited in our second third-party complaint that refers to their knowledge of the matter and the taking of the funds with the knowledge that they belong to the company.
But what did Aman do with respect to the money?
My understanding is that they used it to purchase a house in New Brunswick, New Jersey.
He didn't purchase the house, though, did he?
I'm
It was
sorry,
put in his name,
Exactly,
its
correct,
names, but, okay,
Yeah.
all right.
With regards to our motion to dismiss, our position is that the contract itself fails because of the illegality standard, and we cited some case law in there about that. Basically, it's appellant's position that the plaintiffs were using the operating agreement to perpetrate a Social Security disability fraud, and therefore the contract itself is illegal. So
That depends on information not on the face of the contract. When you're suing to determine that a contract is illegal, you're suing on the basis of what's alleged in the complaint. That's not the case here, right?
Yes, but we did cite two cases that held that a party cannot sue on the basis of illegality if the contract itself is proper, but it's used for illegal purposes. And that's our position as to what's happening here. So basically, defendant appellant's position is that at the very least, the lower court should have held an evidentiary hearing on this issue.
Okay, thank you, counsel. You have time to rebuttal.
Thank you.
Your Honor, may it please the court, Michael Joseph for the respondents. If I can start with the impari delecti argument. In this case, it was an entirely legal contract for leasing vehicles. There was nothing illegal about it, and I think the law is pretty clear that where the alleged bad behavior or illegal behavior is entirely collateral to the contract, and there's no illegality on the face of the contract itself, impari delecti simply doesn't apply. And let's look at what the defendants in this case did. They didn't assert that plaintiff committed any Social Security fraud. They brought in her husband to try to sue the husband and say he engaged in some fraud as a defense to the plaintiff's claim, which is completely improper under the impari delecti. They moved under 3211 which is based on the facts in the complaint to try to dismiss this. And there was no foundation whatsoever to support these allegations of Social Security fraud, because the sole factual assertion was from the defendant, who says, I have no knowledge of any impropriety, but then he makes a whole bunch of accusations, which really undermines his own affidavit, makes it foundationless. So the doctrine doesn't apply. It was procedurally done wrong, and it wasn't even pled as a counterclaim. And they're attempting to assert the actions of a husband as a defense to a contractual claim by the wife. It's the biggest square peg in a round hole I've ever seen in 25 years of practice. Turning back to the contract, the SAJ was the subject of the contract. There was already found in the prior motion a valid cause of action for breach of contract by the members against each other. So therefore, SAJ itself has no cause of action. The cause of action, based on the operating agreement, is between the members, and that's still in play. There was no fraud, because the only allegations of fraud were that the plaintiff or third-party defendant didn't do what they promised they would do. Well, that's not fraud. It's black-letter law that statements of future intent or future promises don't amount to fraud, and they didn't even say with any specificity.
What about all the alleged looting of the corporation, of SAJ's assets? I mean, isn't that part of the fraud claim, or am I missing something?
Well, that would be potentially a conversion claim, which I don't think was necessarily pled against the plaintiff or the DAR. They tried to plead that against the kids,
right?
And the kids never exercised any dominion or control. The allegation was that money was put into a bank account that they were also named on. They themselves didn't exercise any control or dominion over the assets, and we provided proof, documentary proof, that the property was bought entirely personal funds that had no relationship whatsoever to SHA. It was a personal line of credit that was utilized to purchase that property. So I think the lower court really got it right here. Turning back to the remaining causes of action for unjust enrichment, you really have to have no action at law. Here, there's an action at law that's viable, which is the members' rights to go after each other for any alleged looting of the company. So really, the defendants in this case never appealed the first dismissal based upon the court below's dismissal of these rights via each other. This is really kind of a roundabout way to circumvent and collaterally attack a decision that was never appealed, which is also improper. Just quickly on
the first action did not have a derivative claim, did it?
The first action was...
Yeah, the first third-party complaint.
It was not based on SAJ.
It was not based at all on SAJ.
Right,
it was all
like
just based on the members. So now this one is SAJ.
Correct, but they're identical causes of action, identical allegations. The only thing that was...
Different parties.
Was the parties.
Yeah.
So in terms of the motion to quash, I'll briefly say, I think the court below got it right. Velas basically says that a party can't object to a subpoena on a non-party based on procedural grounds. Of course, they have substantive objections, but they didn't raise any. There was no showing at the court below that these subpoenas were utterly irrelevant, which is the standard. There wasn't even a half-hearted attempt to show that the documents sought, which were sought to uncover fraudulent transfers of company assets by the defendants to insiders. That showing was there. These documents are seeking production, the subpoenas are seeking production of documents that are well within the square four corners of the complaint in the causes of action raised, and really this is an attempt to raise a procedural issue to defeat substantive justice, and I think it's improper. Unless you have any questions, Your Honor, I'll rest my brief.
Thank you, Counsel.
Thank you, Judge.
Please.
Just real quickly, with regards to Velez, it's our position that the lower court got it wrong, and that Velez absolutely does not say that a non-party or the party does not have right to challenge a non-party subpoena for procedural grounds. It basically says if the non-parties don't object and the disclosure goes forward, then the notice argument is waived, which is far a different cry than what the lower court stated. In any event, with that said, I will rely on the briefs too, unless any of your honors have any additional questions.
Thank you very much, Counsel.
Thank you.
Thank you both. Matter of American Bridge
Good afternoon, Your Honors, and may it please the court, Christopher Bletch for the appellant, American Bridge Company. I'd like to focus on two errors from the lower court's decision below, in which it should have overturned the decision of the CDRB, which denied American Bridge's claim for extra work for the cost of redesigning this platform as part of its work on the Queensboro Bridge Rehabilitation Project. The two issues pertain to the imbalance of information that the city had as compared
But didn't
to
the city surface that information, that this is what we have, and you got to bake this into your bid? In other words, you have to take the risk that maybe these dimensions are incorrect and make that part of your bid. And didn't they do that in several different places in the bid documents?
I don't agree that they did that, and I think the key language is that they directed the bidders to verify the information in the field. It said the awarded contractor shall verify in the field that these dimensions are correct, which is a completely different situation as opposed to if they had said the bidder must verify this information before submitting the bid.
Said in the general notes that the dimensions and elevations shown were obtained from the original drawings and shop drawings from the original structure and may vary from the actual dimensions and elevations as they exist in the field. Basically, they're saying they were once right. We have no idea if they're right today. Rely on them. You know, that's, it seems to me they couldn't be much more straightforward.
Well, I understand that argument. I think the distinction is, in this case, the bidders were not given an opportunity to investigate or confirm the measurements.
It seems to me under those
I'm sorry.
Go ahead.
I just want to know, did you ask for an opportunity to verify those measurements in the field?
Yes.
When did you do that?
It's cited in the brief.
Was it after you bid?
Yeah, before the bid. No, before the bid. A site tour was given from the sidewalk, and a question was asked, could we have the roadway closed so we can do an on-site investigation? And the city denied that request because it was an active lane of traffic. It's important here that the city controls the roadway, and the cases that we cite, Fellhaber, Faber, and these other cases all rely on the fact that if a bidder doesn't have the ability to conduct that site investigation, then it's not responsible for the variation in the plans and specs that are provided to it.
Are you referring to the items that are on 442 in the record? Because I have here question 13, sort of like a question to the city DOT, and then a response from them.
Yes, we would like to request a site tour.
So that question 13 and that response, I don't see anything in there that says we need to verify any measurements.
Well, so then in addendum number 4, that specific question was asked if the city could verify the dimensions for the vertical clearance of the roadway. And in response, they gave the information that they had, and they didn't say, do an investigation or this is all we had. What they said was then verify it in the field.
But do they need to do that again if it's in many places in the contract already saying you have to verify this in the field? And based on what I have here on 442 of the record, their response was, the request has been denied due to lane closures are not available at this time. Information requested should be on bid drawings, and then it tells you contract drawings at ACCO's office. If there is additional information needed, provide question specifying request. Did you provide a question specifying the request?
Yes, the Q&A asking was in addendum 4, asking for the vertical clearance dimension after this, the request for the site inspection was denied.
Okay,
That was after you bid?
This was before, all of this was before the bid. So the clarification was asked before the bid went in. The verification in the field couldn't happen until after the contractor was given the award.
What tension is there, if any, between your position and on page 327 of the record, paragraph G20 under site visit, that all bidders are urged and expected to inspect the site and to satisfy themselves as to all general and local conditions that may affect the cost or performance of the project. In no event will a failure to inspect the site constitute grounds for withdrawal of a bid after opening or for a claim after award of the contract.
That's right, and I think if American Bridge was given the opportunity to conduct that inspection on the lower roadway and make that measurement, then I would agree that that provision would potentially bar the claim, but they were not given that opportunity.
But if they weren't given that opportunity and you bid anyway, it seems to me that what you would have to do is to build in a fudge factor into your bidding amount to take into account the possibility that the data given to you was out of date and wrong and would have to be modified. So it seems to me that's where that wasn't done. Wouldn't that be the solution to that?
I disagree with that because I think the solution was to verify it in the field, and if the measurements are incorrect, it said to bring it to the engineer's attention, and the engineer is to determine how that discrepancy is resolved, and if it results in extra work, the engineer has the authority to order a change order and pay extra work for the increased cost of performance.
Thank you, counsel. You have time to rebuttal.
Thank you.
Your Honors, may it please the court, my name is Amanda Abata and I represent the city respondents. The CDRB rationally determined the American Bridges contract is entitled the company to extra compensation.
Could you put the mic closer to your?
I'm sorry, yes.
How much?
Yeah, quite simply,
Did they ever request an opportunity to inspect the site to take measurements?
the DOT made a decision that it was impracticable to close down the road prior to the contract in order to allow site measurements. What it did do was allow a walkthrough, and it also provided information with regards to the historical data that it had. But it was
So how were they to confirm that your measurements were correct if they were not allowed to do an inspection?
Well, Your Honor, they were told explicitly that the measurements were estimates. One, that the measurements were estimates and that they had to be verified post-bid. And with regards to, there was plenty of...
How were they going to verify that, whether pre-bid or post-bid, if they were not given an opportunity to do that inspection?
Your Honor, yes, there was no opportunity to do the inspection, but as I said, the contract said that the measurements could not be relied upon, and once the contract was executed, there was a period of time with which they were allowed to access the site and take the measurements. Now, what happened after the contract was registered is that approximately 2 weeks later, American Bridge put in a safety design for the protective shield, and then it was another 6 weeks until they went...
Before they did an inspection?
Yes, and then it was another 6 weeks before they went on site and took the measurements and found out that the safety design was had the wrong measurements. And I would also like to say that an additional option was that the way that they designed, they had the means and methods of designing the protective shield. It was up to them to come up with a design and a way to install the shield that could account for the minimum vertical clearance.
Was that an impossibility? Because I guess it did sag. That was the issue, right? It sagged
Yes.
into the area that it was not allowed to do so. So is there somewhere in the record saying that there's some sag-free scaffolding that could have been installed?
Yes, Your Honor, that was discussed during oral arguments in front of the CDRB, that the fact that there was other options they could have utilized that didn't have the sag. For example, there's an option where the protective shield is more flush, I guess, with the upper part of the bridge versus having what they had here, which was like a 8-inch and then a 4-inch sag. So there were other options available to them. And quite frankly, the fact that the bridge could not be measured beforehand was known to American Bridge. The fact that the measurements within the plans were not verified was known to American Bridge. The fact that the one measurement that DOT provided was from historical data was known to American Bridge. They didn't have to make a bid on this project, and when they did, they certainly had enough information to know that they had to build in as part of their bid to account for the variabilities in terms of the measurement.
I guess that's reflected in paragraph 28 of the vertical clearance that you mentioned.
Yes, Your Honor.
You don't verify the dimensions and measurements before erecting scaffolding or protective sheets.
Your Honor, that's exactly right. That says that explicitly. And I would also say that to the extent that DOT did give inaccurate measurements, as long as it does so in good faith, American Bridge is also still not entitled to additional compensation. The only way they would be entitled to that compensation is if DOT was not open about the fact that it had provided the historical data, it shared where the information came from, and it also explicitly stated multiple times throughout the bid documents of the contract that it had not independently verified the information. So.
Thank you, counsel. Any further questions? Thank you.
Yes, that the court affirm.
Thank you. If I may make 2 points in rebuttal. Regarding the contingency that we talked about before, I would like to point out that the record does show that American Bridge designed the platform with up to 3 inches of sag, with which it could still comply with the clearance requirement, but the dimensions varied between 14 and 17 inches. So even though the measurement that was provided said approximate, that was accounted for in the design of the platform, and it could have sagged up to 3 inches, but it was 14 to 17 inches, and that obviously was too much to comply with the design. And I do think that the argument of means and methods is really a red herring, because there's no evidence that the platform would not have worked as designed had the measurements been as represented or approximately as represented. It was because they varied so greatly from the dimension that was
Sir,
provided.
what provision or provisions of the contract can you point to that most strongly support your argument in favor of additional compensation?
It's the Q&A number 20 that provided the measurement and said that the contractor is to verify in field, because that means if the conditions vary from what was represented, the contractor is supposed to bring it to the engineer, who can direct that the work is extra and it should be compensated. That's the specific, the general exculpatory provisions that the city, doesn't stand behind the measurements, and that there's no compensation to be provided for them, shouldn't be enforced when the specific measurement that was given for the vertical clearance controls.
So are you indicating that the DOT misrepresented or withheld information?
No. No, but it controlled the access to the information. So if it wasn't able to stand by it, knowing that the measurement had to be maintained, it should have either taken accurate measurements itself, confirmed what was in the plans, or allowed the contractor to take the measurement before the bid went in.
Thank you, counsel. Thank you both. Silverstein versus CoolSculpting, Zeltig. Please.
Thank you, Your Honors. May it please the Court, Brian Ginsberg for Zeltik. I'd like to focus on 2 separate grounds for dismissal of plaintiff's failure to warn claims. First, even under the Liriano regime that my friend on the other side says applies, there is no evidence that the use of ice packs on plaintiff's bare skin was foreseeable. Indeed, there's no evidence in the record that any doctor in the state of New York or elsewhere had ever ordered the use of ice packs on bare skin following CoolSculpting. But even if the court disagrees on the point of foreseeability, even if the court is not inclined to go with the Dummett framework that we discussed, even if the court indulges everything my friend on the other side wants to say about the presentation slide, still reversal is required, because independent of all that is the second reason I'd like to discuss with Your Honors, that Zeltik had no duty to warn, because warning Dr. Brower on this record would have been redundant. Dr. Brower already knew that applying ice packs to bare skin rather than over a barrier and intermittently was dangerous, and indeed he already knew, based on his testimony at 993 to 994, that it could cause exactly the same injury, second-degree burns, that Ms. Silverstein claims to have suffered here. The record says that he knows it could cause anywhere from first down to third-degree burns, second being included in that.
Well, of course, it was the nurse who applied the ice packs. Did you have any duty to train her?
No, I mean, let me step back a little bit. Zeltik is a medical device manufacturer. Zeltik does not have, I didn't mean to interrupt.
No, it's okay. Their argument, of course, is that there's that slide out there, and then your witness testified that, no, we don't provide any training on ice packs. So given those two things together, did you have a duty to tell the nurse not to put ice packs on the bare skin of the patient?
Well, we certainly didn't have a duty to tell the nurse, because on the facts of this case, the nurse was not a learned intermediary. In fact, my friend on the other side concedes at page 22 of her brief that the nurse was not a learned intermediary. She calls the notion of the nurse being a learned intermediary disingenuous. But regardless, even if there was that duty to warn or to train in general, which I think is part and parcel of the foreseeability issue and the slide that my friend on the other side talked so much about, still there has to be a reversal and a grant of summary judgment, because even accepting every one of those assertions, Dr. Brower already knew of the dangers involved, he's the relevant learned intermediary, of applying ice packs to bare skin rather than intermittently over a barrier. And my friend on the other side points to no evidence calling that into question. She points to the fact that her treatment was, quote, the first time that Dr. Brower ever dealt with a patient that wanted ice packs after CoolSculpting, but that fact is immaterial here. It doesn't negate, A, Dr. Brower's role as a learned intermediary, nor does it contradict Dr. Brower's knowledge base, which would have made any warning to him redundant as a matter of law.
Sorry, sir, but didn't he go a step further and say that he wouldn't rely on medical device companies for guidance as to how to practice medicine or how to treat a wound or a sequelae from a procedure?
He did go a step further, Your Honor, and that brings up yet a third ground for complete reversal, which is that even accepting foreseeability, which we disagree about, even accepting that there was a duty and that you can get past whether any duty would have been redundant to Dr. Brower, still, as a matter of law, there was no proximate cause, because there's no evidence that Dr. Brower would have heeded a warning from Zeltiq regarding the use of ice packs to manage post-treatment side effects. And Ms. Silverstein does not even purport to point to any evidence in response. She makes the legal argument that she ignores Dr. Brower's statements that Your Honor just quoted, and she says that, well, even if Dr. Brower wouldn't have heeded that warning, still perhaps Nurse Mahoney would have heeded a warning, or perhaps Ms. Silverstein herself would have acted differently had a warning been issued.
I have two questions for you.
Yes, Your Honor.
Did the machine function as intended?
Absolutely it did, Your Honor.
Second, did the machine require the use of ice packs in order to function as intended?
No, it did not require the use of ice packs. The use of ice packs came after the use of the machine. It came later chronologically. And if you look at Dr. Brower's testimony in the record, he testified at pages 847 to 882 that he had performed CoolSculpting approximately 122 times, but had never had a patient ask for ice packs to manage post-treatment swelling. And then at page 1025 of the record, and I'll sit down after I finish this point, he also said, in general, the treatment I do offer patients post-treatment for swelling is prednisone. So that's why under the controlling test under Dummett, which we think is the proper analysis, that, as the Court of Appeals said, defines the common sense line at which duty ends based on any duty one manufacturer might have to warn about dangers associated with the product of another manufacturer. There is no synergistic product use here because, as Your Honor just pointed out, there is no necessity, economic, practical, or otherwise, of using ice packs manufactured by a third party with the Zeltiq medical device. And I'll reserve the remainder of my time.
Thank you, counsel.
Good afternoon. May it please the court. I'm Annette Hesapitas, appearing for the plaintiffs in this case. I'd like to recast this pretty quickly. The purpose of product liability law is built on the notion that a manufacturer who places a good in the stream of commerce, especially for profit, bears the responsibility to warn of the dangers from reasonably foreseeable uses. And in this case, this defendant is stating that once the machine was turned off, their liability was over.
What about for obvious risks?
I'm sorry?
Obvious risks like putting ice pack on a bare skin. Is that something you'd have a duty to warn?
Yes, this wasn't, well, it's not just putting the ice packs on the bare skin, but also for the duration of time. Dr. Brower also testified at page 990 that if the plaintiff had been instructed to remove the ice packs before she left the office, she wouldn't have suffered those burns. So it's both the duration and the placement of the ice packs on the bare skin. And this isn't an obvious risk. We are talking about using cryoliopsis to freeze the skin. This is not something that ordinarily occurs in the practice of medicine. Physicians aren't trained how to deal with frozen skin generally. This is artificially done to achieve a cosmetic purpose. So in this case, it was not an obvious risk that she would sustain second and third degree burns as a result of wearing the ice packs on her bare skin for over 30 minutes.
What about the causation argument concerning Dr. Brower?
Again, this goes back to this isn't merely the practice of medicine. This is about post-treatment care for patients who suffer swelling. They acknowledged the use of ice packs to deal with a late onset pain.
Where do they acknowledge that? Just in that slide, right?
Yes, in the slide at page.
Okay, and the slide's audience are doctors, right? Not patients.
That's correct. But the slide, once they say that this isn't them and this isn't them acknowledging a duty concerning post-treatment care because it's put forth by clinicians. So that's another thing that is a loophole that they're trying to create in the product liability law. We didn't say that. Our clinicians make these recommendations. This isn't a duty of care. That's another dangerous argument that they're making here. That would be like saying that Honda can put forth recommendations of drivers about the use of vehicles and then later disavow any responsibility for passing off or conveying those recommendations.
In your hypothetical, though, the car salesman would have to be a learned intermediary.
Well, but
I mean, I don't think the
Yes,
auto
yes,
manufacturer example
That's
takes
correct.
into account the variable here of the learned intermediary.
Right, okay, well, the learned intermediary could be a mechanic at a Honda dealership, but then or at another dealership, and you can't avoid your duty by saying, well, we're just passing this along. This isn't us. We have no duty here.
So once they say, after you have received this treatment, don't use ice packs, and they're telling that to a doctor who already knows it from his or her training that you can't put ice packs directly on skin, because if you leave it there for a long time, it's going to cause certain effects.
Well, Your Honor, they never said don't use ice packs. It is a recommended use to treat late onset pain in the slide that's at page 2100 of the record. So that's the problem here. Once they put forth that slide, they had an obligation to say, be mindful of keep using a barrier, intermittent use, be mindful that the patient has frozen skin. They can't tell whether or not they're suffering burns or burn injuries, right? When you have a normal person using an ice pack on their bare skin, they'll know they're going to get frostbite. That didn't occur here. And for them to say that...
Wouldn't this be something that a medical doctor knows from his or her training?
Not with respect to cardiopsis. A doctor is aware that extreme cold can give rise to second and third degree burns, but a doctor is not necessarily aware that after the patient's skin has been frozen through the CoolSculpting technique, that frankly, ice packs, or at least limited use of ice packs, must be undertaken. In their literature, they're actually recommending the use of ice packs following the treatment. So once they do that, they have to qualify what that is. And here, they've tried to disavow it by saying this is coming from clinical recommendations. This isn't a duty of care. And I would like to point out that we're just looking for a jury trial here, right? They've argued that they owe no legal duty and that there is no question of fact even if they did. The position here is that we're entitled to have a jury determine whether or not they were obligated to do more than they did here, even though they were advising a doctor. It's our position that had Dr. Brower been advised in the manual or in the slide that the use of ice would have created second and third degree burns within a certain period of time, it would not have occurred, and he would have warned the nurse.
Thank you, counsel.
Thank you.
Just a few points in rebuttal, Your Honor. Whatever might be said about the duty to warn doctors in general or other doctors in other cases, it remains the case here that a warning would have been redundant as to Dr. Brower for the reasons that we discussed. Now, my friend on the other side says, well, even if Dr. Brower or physicians generally knew about the dangers of applying ice packs to bare skin, they might not have known about that in the CoolSculpting context. The record negates that notion with respect to, first of all, Dr. Brower testified that this is obvious medical knowledge, period. He was speaking categorically. You never apply ice packs to bare skin, no matter what. But he also stated that that was his advice, quote, in our practice, referring to his work at laser surgery and skin. And he also qualified it by saying that that's what he does in, quote, my practice, again referring to his work that included, as I discussed with your honors in my opening presentation, 122 CoolSculpting presentation treatments, and that's at page 995 of the record when Dr. Brower indicates that he has that knowledge in the CoolSculpting scenario in particular. It was the first time I heard today on my friend's presentation that Dr. Brower might have done something differently had he been given the warning that Ms. Silverstein thinks he should have been given. Still, though, I didn't hear her point to any evidence to that effect, no record citation, and there was no record citation to that effect in the brief either. There's simply no evidence to contradict our prima facie case that even if you were to get past foreseeability, which we don't think you should, even if you were to get past no duty based on redundancy, which we don't think you should, that still summary judgment should have been granted based upon no proximate cause, because there is no evidence that Dr. Brower would have heeded a warning from Zeltiq regarding the use of ice packs to manage post-treatment side effects. So unless there are any further questions, I'd ask that the decision below, as to Zeltiq, be reversed and summary judgment be granted.
Thank you, counsel.
Thank you, Your Honors.
Thank you both. Rudkosi versus New York University.
Good afternoon, Your Honors. My name is Joseph Carbonero. I represent Sidney Rudkosi, the appellant in this matter. I would just sort of boil the issue down here to following. The lower court applied what's known as the academic judgment rule, viewing this case strictly as an Article 78 petition in a plenary action under New York City and New York State human rights law, finding that somehow that a student who requested an accommodation for a disability, meaning a psychiatric and/or medical disability, that determination that the lower court, that the university made, was somehow academic in nature.
But we have so held, right? Matter of Kickerts, Gary versus New York University. How do you get around those cases?
Well, because in all of those cases, Your Honor, the crux of it is that they are academic decisions. What we are saying here, and what I think is consistent with Kickerts and with the St. John's case.
In this case, I mean, in essence, isn't she asking to relax academic standards?
No, not at all.
She's not?
No, she's not asking to relax academic standards at all. What we're focused on is the accommodation. The accommodation.
But she got an accommodation for she took the test twice and failed twice, right?
Correct.
So and she got an accommodation for extra time, right?
After the fact, what happened was, she took test number one, she failed. The entire class was given the test a second time.
Which is routine.
Which is apparently routine, I would agree. After the second administration of the test, Ms. Rudkosi came to the administration or to the professors and said, I need extra time. And this is why. And the reason why, as is made out in the brief, has nothing to do with academics. It has nothing to do with her inability, her lack of knowledge, her lack of effort. It has to do with her brain. It has to do with the way her brain functions and how she processes information. Her brain functions in such a way that she cannot process the type of information that she had to process on the exam. Now, NYU had ample opportunity to let her retake the exam a third time. It did so with respect to other students who had medical disabilities, who clear-cut medical disabilities, I should say. But Ms. Rudkosi's disability was ADHD and anxiety disorder, and we set out in the brief, I think more clearly, what the nature, and certainly in the amended complaint, what the nature of the disability was and what it did to her. And what it did to her was it affected the way she's able to answer certain questions. And it affected that.
Sir, I'm sorry to cut you off, but Granted, this is not the traditional, I don't like my grade and I was treated unfairly, and not the traditional, I don't agree with the discipline that was meted out by university. This is something different from those. But it all seems to circle back, though, to a test or an exam. And so doesn't that go back to what I think Justice Moulton said earlier about the observation in Kickert's that if it relates to academics, then it has to be treated under the Article 78 rubric?
It's not related to academics. The reason I say that is because she was seeking an accommodation under the New York City and New York State human rights laws. And the accommodation was not so that she could take an easier test or so she could skip certain questions on the test. The accommodation was so that she could have additional time on the test. Now, you could analogize this to situations in the K through 12 scenario where where a committee on special education would analyze a student's disability and make a determination whether that student is entitled to certain accommodations. Instead, here we had professors who are dental professors making that determination, and they're not experts. And in this case, what Ms. Rudkosi was asking for was not to take a different test, was not to take a qualitatively different test. She was asking to take the same test.
So what kind of issue or determination we characterize this as? It's not academic, certainly not disciplinary. So what would we characterize?
I would characterize it as either psychiatric or as medical, but it is not in any way academic. It has nothing to do with pedagogy. It has nothing to do with the curriculum. It has nothing to do with discipline. It only has to do with psychiatry and or medicine.
Thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors. May it please the Court, Rebecca Kimura on behalf of the respondents. The court properly found that all of plaintiff's causes of action were subject to exclusive Article 78 review because they did stem from NYU's academic decision to deny plaintiff her request to modify and relax the academic standards. She wanted to take the exam a third time. She did not ask for an accommodation before the first or second time. NYU defendants granted her every accommodation she requested. In fact, she pleads in her complaint that she got an accommodation.
I'm sorry, counsel, maybe I'm mistaken about the record, but on the first two times she took the CPC exams, she had time and a half, is that correct?
Correct, because that was the accommodation that she requested and that her medical provider recommended. So it is not the defendant's job or duty to determine that she needed an additional accommodation or to second guess the accommodation that her medical provider had recommended. They gave her every accommodation that she requested, which was a time and a half. Even after the first administration exam that she failed, she did not request a second examination, a different accommodation. She only requested it after she failed the second time. Then she requested to take the exam a third time. That is not a request for reasonable accommodation for a disability. That is a request to relax the academic standards for the college. Nobody else got to take the exam a third time.
When she asked to take the exam a third time, did she ask for an increase in the amount of time allotted?
Did she ask?
From time and a half to maybe 2 hours?
She did. She asked for double time to take the exam the third time. Had she been allowed to take it the third time, then they would have allowed her to have that additional accommodation. But the point is, it wasn't a request for double time that they denied. In fact, the defendants did give her the accommodation of double time after the fact. So going forward, she was able to use that additional accommodation. But for the two exams that she did take, she never requested a different accommodation. So this is not a case about failure to accommodate. There was no request for another accommodation prior to failing 2 times. It was the request to take the exam a third time that was denied, and that had nothing to do with her disability. That was the standards that NYU set out in its academic standards for the College of Dentistry. NYU has accreditation responsibilities. They have to make sure that their students are fully prepared to care for their dentists, for their patients. And so what plaintiff was asking for was something that nobody else got, disability or not. They could only take it the second time, and she couldn't remediate the course because NYU only permits remediation if you don't fail a course, and she had failed the course.
Was there
So
evidence in the
they were-
record
she was
that
not treated-
somebody, that a student, I'm sorry, that a student with medical issues, physical medical issues, was allowed to take the CDC exam a third time?
That's not true. I don't know where that's not in the record anywhere either. Nobody was allowed to take the examination the third time. There were some students who were allowed to take it at a different date. I think that's what counsel from the other side might be pointing to, but those were the people who didn't take it a second time. Those individuals sat on that later date for the second administration of the exam. There was nobody who was permitted to take it a third time.
But there were some people who were permitted to retake a quiz rather than accept as 0 and then use that as their, then be in the position of using the one grade they get to drop as that 0.
That's correct, and the plaintiff had that same opportunity. Everybody had that same opportunity to drop one quiz grade.
But
She had
she had
already
to-
used it. She had already used it, so she couldn't also drop this as well. That's all part of the academic standards. That's in the academic standards policy that the defendants never deviated from. She was treated just as everyone else, and what she was requesting was not an accommodation in this case. It was to relax the standards so that she can take another administration of the same test.
Thank you very much, counsel.
Just a couple of points, if I may. First of all, there is, this was on a 3211 motion, so we are looking strictly at the amended complaint, and the amended complaint does plead, in fact, that some students were permitted to take this exam a third time. When you look at the amended complaint, again, I'm sure you'll see that. I would say also that, and to Your Honor's point, double time is what was requested, and it was requested after the second administration of the exam. So what I'm saying is that there was plenty of time, since NYU had given this exam to a third time to other students, they could have given it a third time to this student, but they didn't. And you'll see in the amended complaint that what the professors essentially do is give short shrift to this complaint of a disability because it's not a physical disability. It's a psychiatric disability. It's an adult attention deficit disorder disability and extreme anxiety disability. So you'll see pleaded in the complaint is that when she met with her professors, they effectively refused to engage in a dialogue with her about what kind of accommodation she was entitled to, which is blatantly in violation of the New York City human rights law.
Thank you very
Didn't
much.
they give her the accommodation?
sorry?
Weren't they giving her the accommodation when she asked for it, before she failed?
She asked for it before, she asked for it after the second administration of the exam. She tried to take the exam with time and a half. She asked for the additional accommodation of double time after the administration of the second exam, which could have been granted had they wanted to. Thank you.
Thank you, counsel. Thank you both. Finally, Samsung's Electronics versus MPEG LA. Please.
Good afternoon, Your Honors. Garrett Beeney on behalf of appellant and defendant below MPEG LA. Your Honors, the decision and order and judgment that we appeal from adjudicated the rights of non-parties under a contract to which no litigant is a party and determined that $25 million held by those non-parties should have been paid to Samsung because those non-parties could not count the vote to amend their agreement the way they counted their vote.
Well, let's start with necessary joinder then, shall we? So I agree with you that the trial court didn't reach the second leg or part of that because it's an or, not an and. But how were they inequitably affected by the decision?
They were inequitably affected by the decision, Your Honor, because they were not present to defend the way they voted. They were not present to show the court how they could vote to amend their agreement. They were told that they could not count the votes the way that they agreed to count the votes and that their amendment failed.
Yes, but within the term inequitably, doesn't it also mean that we have to look at the merits to a degree? And here, the merits are, the other side asserts, that the vote was by silence, didn't count.
Well, let me then, if I may, at least very briefly address the issue of the underlying determination that the vote was improperly counted. First of all, there's nothing in the agreement that says how the votes may be counted. I don't think there's any dispute about that. Second of all, the trial court relied on the doctrine of expressio unius, but did so by relying on a provision that really has nothing to do with the provision that was used to amend the agreement. The provision that the trial court relied on had to do with an action taken by a non-party to that contract, my client, MPEG, to change the scope of a third agreement, a license agreement. And the only right that the licensors, the patent holders, under the agreement among licensors had under that agreement was to say no. They couldn't vote yes or no, and it certainly wasn't an amendment to their agreement. And if you look at the...
I mean, it seemed to me that she was relying, she did use expressio unius, but she was relying more that like section 6.3, which is the provision in question, it just showed that the parties knew how to talk about silence and how it would affect a vote.
They certainly did, but on a completely different area.
Yeah.
And the only thing that's required under section 6.1, which is the amendment provision that the motion court adjudicated without the presence of the parties to that agreement, the only thing that provision says is that there must be a vote, that there must be a vote of the administrative committee, which is the group of patent owners that contribute their patents to the license. There was a vote of the administrative committee. And not only had the parties decided historically to count no voting as an affirmative yes, but Samsung had participated in a vote to do exactly that. And in this very litigation, Samsung witnesses testified that
So we don't need any parole evidence, you're saying. The AAL is correct.
I think there's an argument that it's parole evidence, Your Honor, but I also think that it's an argument that it's not parole evidence because you have Samsung's witnesses in this litigation testifying as to what they believe about an argument that's being made in the case. They testified that there was nothing wrong with the way the votes were counted. How can summary judgment be entered contrary to the position of both parties in the case of how the agreement should be interpreted? It at least goes to the issue on summary judgment as to whether the language was clear. You have both parties in the case, neither of whom were parties to the contract at issue, but you have both parties in the case saying that this voting method was completely appropriate, and you have the trial court saying, oh, no, it's not. And I would just add on the voting, it's important to recognize that the voting thresholds to amend the agreement are directed to the entire group of licensors, not just those who vote. So you have to count someone who doesn't vote as a yes or a no to meet the threshold. And just by way of an example, suppose you have 10 licensors and you need 75%. 7 vote yes, 3 don't vote. Under the trial court's ruling, that amendment fails even though nobody voted against it. Under the way the licensors decide to construe their contract, the vote passes. So the parties to the contract were necessary because it was their money, it was their decision, it was their contract, and they are not only inequitably affected because of the way that they were telling the trial court told them they may or may not vote, but also because the trial court disposed of $25 million that they decided should be distributed to them and is being held by them.
Right, so that MPEG-LA has to claw that all back, which is a big Megillah.
Well, and the trial court even recognized that it wasn't MPEG-LA's money. The trial court suggested that MPEG-LA could sue the licensors or it could withhold distributions to the licensors. Yeah. That's exactly what 1001 of the CPLR tries to prevent. Duplicative and potentially inconsistent litigation. And I will say, I'm sure your honors were here, that this is all activity by MPEG-LA that was at the issue here. But it was not. The only issue that resulted in the judgment was the trial court's construction of the agreement among licensors, to which none of the litigants are a party. And that's clear in the trial court's memorandum decision. She said that there was a breach of the agreement that MPEG-LA is a party to only because of and as a consequence of her resolution of the agreement among licensors. And the entire brief of Samsung in this court, before you get to the issue of necessary parties, is all directed to what can be done under the agreement among licensors, to which no party to that agreement is a litigant here.
I don't know, on rebuttal, you should talk maybe a little more about that, because they were signed the same day. They're in a symbiotic relationship somehow, the AAL and the LAA. But anyway, for now, counsel, let's hear from the other side.
Thank you, Your Honor.
Thank you, Your Honors, and may it please the court, William Adams for Samsung. I'd like to start with the necessary party issue. Justice Crane properly exercised her discretion in ruling that no party other than MPEG is a necessary defendant in this case. The dispute is solely between Samsung and MPEG over the breach of the licensing administrator agreement. The money judgment that was entered here, or after summary judgment at this point, was entered solely against MPEG. It doesn't require the licensors to do anything. It doesn't direct how MPEG is supposed to satisfy the judgment. It doesn't say they have to call it back from the licensors or direct anything with respect to the licensors.
Where's the money going to come from then?
Well, they could, of course, they could have impleaded the licensors here, and we know from this court's precedent, including the Eclair decision, that is what a defendant should do if it's concerned about where it's going to be able to recoup the money. It can go back and negotiate with the licensors over a new distribution, an offset, or something like that. But the judgment itself does not direct any particular course of action, and there's no inequitable effect. There's no inequitable effect on the licensors here, because first off, they could have intervened. This court's decision in American Realty is directly on point there. They had full knowledge of this case. They've just been sitting.
Some expressed misgivings too, I think.
I'm sorry, Your Honor?
Some of them expressed misgivings about the 50% reduction.
At the outset, Your Honor, they wondered what would happen. They said there could be a suit here. What will happen? And MPEG assured them, no, everything will be okay. This is permitted, and you don't have to take it from me. You can take it from MPEG's own counsel. Their hands are all over this. They proposed the amendment, advocated for the amendment, counted the vote, said the amendment passed, and then changed the text actually after the fact. These are the record 1124, 1128, and then 2017 to 2020. Their hands are all over this, and the licensors have sat on the sidelines. If they're concerned about how to recoup the money, they could have impled the licensors, but they didn't. If there are no more questions about the necessary party argument, happy to turn to the merits. Justice Crane was absolutely correct in ruling that MPEG's reliance on the silence as assent contravened AAL 6.1. The voting rule is expressly permitted for amendments to the HEVC standard under AAL 6.3, but it is absent from AAL 6.1, which is at issue here. So this is a textbook application of the expressio unius doctrine, and silence doesn't constitute assent for amendments like this one. My friend says these are totally different contexts. You shouldn't be comparing it. It's apples and oranges. Not so. These are absolutely parallel situations. I would direct the court to R342. That is AAL 6.1, and it actually specifies several different types of amendments to the AAL. 2 of those 4 amendments are at issue here. One is what we're talking about, the 75% threshold that they say they satisfy. The 4th one at the end of the list is amendments under 6.3. The AAL treats 6.1 amendments and 6.3 amendments as two different types of amendments to the AAL, and therefore it's a proper parallel situation for purposes of the of the expressio unius doctrine. I'd also direct Your Honor to section 1.15 of the AAL. That says that sets out the default standard for the HEV standard, and if you were to have an amendment under section 6.3, that's going to amend what's in section 1.15. These are amendments, it's parallel, and it's absolutely the same conduct. In 6.3, just as here, MPEG would make a proposal, and all licensors would be deemed to approve it until they expressly voted no. You can do that under 6.3. You can't do that under 6.1. I'd like to, so it's unambiguous. You don't need to look at any parole evidence. You don't need to look at the extrinsic evidence. But if you were, for some reason, there's certainly no evidence evincing a course of conduct or a course of dealing that's contrary to our interpretation. My friend relies on a snippet of deposition testimony from one Samsung witness. That's at 2282. He didn't cite that. But if you also look at 3276. There's testimony from another witness, another Samsung witness, which says, I don't think that that's, I don't understand that silence is assent is a proper reading of this contract. So Samsung's witnesses were frankly contradictory on that point. There's no course of performance or certainly course of dealing with respect to that issue, and there's never before been an instance where silence was determinative and dispositive of the vote as it was here. You don't need to reach it, but I will just flag another issue that's in our brief, and it's the vested rights doctrine. That's actually the most fundamental problem with this amendment here.
I didn't follow that argument. You're basically saying that you guys should have had a vote?
I'm sorry?
That your client should have had a vote, should have been included in the vote?
Well, under the vested rights doctrine, as most clearly explained in the Court of Appeals decision in Colby, that where you have a vested right, you can't be taken away without your assent. So absolutely, Samsung had to have a vote. And the reason we know that there's a vested right here to particular amounts of allocations as of the termination date is because the contract uses mandatory language of a permanent duration fixed as of termination. It's just what the Court of Appeals said in Colby constituted a vested right and didn't allow.
I don't know. If you're arguing that the contract could have been clearer about silence in the context of voting, I think the contract certainly could have been clearer about people who have exercised their termination rights still being allowed to vote about this so-called vested right. So I don't find that to be your strongest argument.
I think there is a provision that requires assent of all licensors in certain circumstances. We haven't argued that expressly here. But one final point, I see my light is on, but you would about whether the status of Samsung as a party to the agreement. There's a dispute among the parties here as to whether Samsung is still a capital P party under the agreement. You don't need to resolve that for this appeal. But I think there should be no dispute that Samsung is at least a little p party to this case. It still has obligations to contribute its intellectual property to be part of sublicenses under the pool, even though it's terminated, and it's still receiving benefits of the contract in the form of some royalty payments. We think it should be 100%, not the 50%. But at the very least, we're still a party, as that term is understood as a matter of contract law, not necessarily as a matter of sort of the term of the contract.
Thank you, counsel. I think we take that point. Thank you.
Very briefly, MPEG-LA's actions in proposing the amendment and counting the votes are legal irrelevancy. These are sophisticated parties. This is Fujitsu, Siemens, Apple, Columbia University. Whatever MPEG-LA may have done to recommend what they do with their contract and their vote, maybe if we have these parties in front of us who should be here, they can testify about what influence MPEG-LA had. But you can't assume that MPEG, by advocating for the reduction, had any influence on what they did under their contract. It is the agreement among licensors that caused the outcome here, and no party to that agreement was before the court. Samsung's brief at 6 says that the agreement among licensors, the contract as to which there is no party here, is key here. We agree, it is key here. It controls the outcome. And as to vested rights, that issue is fully briefed. It's going to be argued next week in front of the motion court. Samsung did not make that an issue here, except as another ground to approve. Second of all, this was summary judgment. The fact that 2 Samsung witnesses disagreed about whether this was an appropriate way to vote should have meant there shouldn't be summary judgment, not that there should have been summary judgment. And finally, I would say as to voting, the 6.1 vote is says that it is a vote of the administrative committee. When Samsung terminated under section 7.2.2 of the agreement on licensors, it lost the right to participate as a member of the administrative committee. Nothing could be more plain that it has no right.
You just quoted 7.2, right?
Yes, Your Honor, and I've got it right.
Okay, no, that's all right. We got it.
I'm sorry, it's 7.2.1. If I may just find the sentence.
No, we know where it is. It's in your brief, too. I mean, you made that argument.
Okay, thank you.
Yeah, thank you very much.
Thank you, Your Honors.
Thank you both.